The concept of reservation is known to us, Tamil Nadu, more than any other state. Because we are, right from 1916, we are advocating reservation, and from 1927 onwards, we were enforcing, exercising, enjoying reservation in Madras province. Though in 1927, it was reserved only for non-Brahmin Hindus, but not to backward class Hindus. Only in 1947, the reservation was extended even to backward class Hindus by Omandur Ramasamy Reddyar. So when this reservation was in force, actually in practice, the constitution was drafted from 1946 to 1949. At that point of time, when the after independence, the largest province in British India was Madras province. In this Madras province, we have been practicing following reservation right from 1927 onwards. But the Constitution Drafting Committee did not take cognizance of this reservation policy we have been adopting right from 1927 onwards. It was completely, though there are 49 members from Madras province representing this committee, this drafting Constitution Assembly, including C. Subramaniam, Kamaraj, Omandur Ramasamy Reddyar, Kakkan, and Munsami Pillai, and so many others were representing. Not even one person objected or insisted that reservation should be made even for backward classes in the Constitution. Therefore, there was no reservation made for backward classes as we have been following right from 1927 onwards. Whether at the same time, the Constitution reserved for scheduled castes and scheduled tribes. That is because in the Article 330 to 32, reservations have been made in the assemblies and parliament. Therefore, it was necessary for the Constituent Assembly to define what is the meaning of scheduled castes and scheduled tribes. Therefore, Article 366, 24 and 25 defines scheduled caste and scheduled tribes. But Article 16, Clause 4, enabled Parliament to states to make reservation in the government state employment of under the state. But the term used there was the reservation may be made for backward classes of citizens. But what is the meaning of backward classes? That was not defined in the Constitution. Therefore, the problem arose, what is the meaning of backward classes? But scheduled caste and scheduled tribes was also included in the backward classes, that is everybody knows. Even just Dr. Baba Sahib Ambedkar also stated somewhere, sometime, the word backward classes is nothing more than certain specified castes included in the list. That is what he said. But it was restricted only to scheduled castes and scheduled tribes. There were no reservations for backward classes, as we have been following. That is the reason why immediately the Champakam Rajan case resulted in a failure. It struck down a communal GO which was followed in India, Tamil Nadu. Then after that, the First Amendment came, Article 15.4 was introduced. Even in the Constituent Assembly itself, when 16.4 was added for making reservation in the employment of the state, Article 340 was introduced. 340 says, it is not as if, it looks as if the Constituent Assembly was not unaware of the fact that there was one community called backward class community, as we know, and therefore they introduced Article 340 in the Constitution itself. That says, insofar as the socially and educationally backward classes are concerned, a committee shall be appointed by the government to identify the problems faced by the backward class, by those communities, by socially educationally backward classes, and to make appropriate recommendations to the government. So 340 requires the government to appoint a committee to find out the difficulties faced by the socially and educationally backward class of citizens. But even this phrase, when Article 15(4) was introduced into the Constitution, where specifically a phrase socially and educationally backward classes have been introduced, that term was not defined. The most important aspect is a definition must be there to understand what it is. Normally, in any constitution, you will not find definitions. That is another aspect. I have also stated definitions should not be there in the constitution. But here, when all the other things are defined, when social educational backward classes is not defined, it's something not a correct attitude. Therefore, all the problems arose, and that was the reason. And the not defining the term social educationally backward classes in the Constitution was the sole reason for all the difficulties we have faced from 1950 till 2021. So had the phrase socially educationally backward classes had been defined in the Constitution in the either in 1950 Constitution or 1951 amendment, all these problems would not have arisen. But nobody was there to address, nobody was there to advise the Prime Minister or the Cabinet that the definition must be included. Therefore, definition was not included till 105 amendment. And this was the sole reason, only reason for all the troubles we have been facing. We suffered. The backward classes suffered from 1950 onwards till 2021, only because of this reason of not defining what is the meaning of social education backward classes in the Constitution. That was the only reason. And Article 340 did not define social education backward classes, and therefore, pursuant to Article 340, Government of India appointed a first commission of backward classes, that was the Kalelkar Commission. That commission also gave the report, the basis for determining backward classes is the caste. But the chairman, a very funny situation arose, very not a good situation. The chairman of the committee, Kalelkar, wrote a letter, I don't agree with my own report. Therefore, that report was rejected. That was not even discussed by the parliament at all. And later on, the second commission was appointed only in 1997, by 1997, no, I'm sorry, 1979. That was Mandal Commission. Mandal Commission gave its report immediately thereafter, but that committee's recommendations was discussed in the parliament more than once. Just R. Venkatraman, former President of India, also when he was a minister, writes as to what was the discussion that has taken place in the parliament, and subsequently in 83 once again the report was discussed, and there P.C. Sethi records that the government wants to implement the recommendations of the Mandal Commission in 1983, but nothing was done. Only in 1990, when V.P. Singh became the Prime Minister, he enforced this recommendation of the committee, and even there he wanted to be very cautious, he wanted to toe a very cautious, safe line. Therefore, he did not bring reservation for both employment and education, but he brought only for employment. That was so only for the state employment, 27% reservation was made by V.P. Singh. That was by an office memorandum in the year 1990. But he did not continue for a long time as a Prime Minister. There he was dethroned. Thereafter, V.P. Narasimha Rao became the Prime Minister, P.V. Narasimha Rao, and he passed another memorandum whereby he introduced 10% to be reserved for economically backward classes. Both these office memorandums were considered by the Supreme Court in the year Indira Sahni's case. The Indira Sahni case, you know everything, most of the things you know, but only I want to point out only one aspect. The Supreme Court in this case has categorically recorded that neither the Constitution nor the law prescribed the procedure or method of identification of backward classes, nor is it possible or advisable for the court to lay down any such procedure or method. It must be left to the authority appointed to identify Identify. Identification of backward classes can be done with reference to castes. This is what categorically stated by Justice Jeevan Reddy in his judgment. Jeevan Reddy judgments supported by 3 other judges, but almost all the 8 of them out of 9 judges, 8 judges said creamy layer has to be excluded. Otherwise, it will not be backward classes. This judgment was given. The judgment in Indira Sani case came only because of this lacuna, namely the failure to define what is the meaning of socially, educationally backward classes, either in the Constitution or in the Office Memorandum. Office Memorandum is only an executive order that cannot do all those things. An act should have been passed for that purpose. In that act, a definition should have been made as to what is the meaning of socially, educationally backward classes. Had that been made in 1993, this judgment would not have been given by the Supreme Court of India. So, in the absence of the definition for backward class, socially and educationally backward classes resulted in exclusion of creamy layer. That is how it has come into. So, this in 1991, only reservations were made only in the employment of the state. So far as the education was concerned, no such reservation was made in that order. For that, in the year 1990, later on, I think it was in 2006 or 7, 2006, I think, an act was passed by the Parliament making reservation for backward classes, reservation in education institutions for socially educationally backward classes and also for economically weaker section, I think. This decision, this bill was introduced in the Parliament. Even before the bill became an act, a public interest litigation was filed by Ashoka Kumar Thakur. On his name, you can find number of cases filed by him. He has filed repeatedly number of cases on various, mainly on these reservations, and he files a PIL before the Supreme Court. Even before the act was made, even before the amendment was passed, it became an act. At the bill stage itself, a petition was filed, a PIL was filed. It is a very strange situation where case could be admitted by the Supreme Court even when when it has not become an act. It was premature at that point of time. The court should have thrown it out as it is premature, but yet it was admitted, and that was Ashoka Kumar Thakur case versus Union of India. That was decided in 2008. In that case, what was the view of the government of India? So just the two persons, that is two leading advocates, one Vaganvati, who was the Solicitor General of India at that point of time, and senior advocate K. Parasaran from Tamil Nadu. He was representing government of India. Both of them said, exclusion of creamy layer is a bad policy. This is recorded by Justice Dalved Bhandari in his judgment on paragraph 14. He says, exclusion of creamy layer is a bad policy. It is a statement made in the Supreme Court not by ordinary person, ordinary advocate, by the Solicitor General of India. That means he represents the view of the government of India. The government of India's view was that exclusion of creamy layer is a bad policy. Parasaran also endorses this and say it is a bad policy. But yet, the Supreme Court said creamy layer should be excluded. Here, I want to point out one thing. In the Indira Sani case, the reason for exclusion of creamy layer was the absence of definition of social educationally backward classes. Because that is why they say neither the Constitution nor the law prescribe the method of defining. Therefore, in the absence of that, we cannot do that. We cannot define that. Therefore, we don't define that. Only the state can define. Only the government can define. All those things were categorically stated in that judgment. In Ashoka Kumar case, Justice K.G. Balakrishnan, and he gives a separate judgment by himself. Justice Arjit Pasayat and Thakur, he gave two persons to give a different judgment. Justice R.S. Ravindran gives a separate judgment, and Dalveer Bhandari gives a separate judgment. 4 judgments were there. In that, Justice Balakrishnan has stated like this. In paragraph 155, it is stated, as noticed earlier, because there he is referred to so many, the judgment of the Indira Sani case, where it said exclusion of creamy layer, why it is necessary to exclude creamy layer from the backward classes, list of backward classes. All those things he records, he extracts everything. And finally he says, as earlier referred, because he refers to that earlier, backward classes, because in this act, section 2G defines what is the meaning of social education backward classes. Unlike the OBC, unlike in the Office Memorandum of 1990, in this act, OBC, SCBC has been defined in the act itself. Section 2G defines what is the meaning of socially educationally backward classes. He says, as noticed earlier, backward classes defined in section 2G does not exclude creamy layer. It is a known fact. Definition is there. Definition government says we do not want to exclude creamy layer. That is what Bhaganwadi also says in the argument. The government's exclusion of creamy layer is a bad policy according to the government of India. But the judge says, therefore, as noticed earlier, backward class defined in section 2G does not exclude creamy layer. Therefore, we make it clear that backward classes are defined in section 2G of the Act must be deemed to have been such backward classes, by applying the principle of exclusion of creamy layer. Though the definition does not exclude creamy layer, the government of India representative says the government policy it is not to exclude creamy layer. The court also records the government section 2G does not exclude creamy layer, but still the court goes on to say we want to exclude creamy layer. That is how in the education also the creamy layer has crept in. Here I want to point out one more thing. This Justice Balakrishnan judgment it is a bench of 5 judges, whereas Indira Sani's decision of 9 judges. So the decision of 9 judges is binding on the 5 judges. When the 9 judges say neither when the Constitution defines or when the Act defines, we are bound by that. The 5 judges say we are not bound by that. I leave it with that. I don't want to comment beyond this because it may go in a different line. So I don't want to comment beyond that. So this is how it has come into reservation, exclusion of creamy layer was made applicable even in education institutions. Here there is one other important aspect most of us fail to understand, fail to note, even though we know that we fail to understand, that is, Indira Sani case was decided only on the employment under the state. It did not decide on the issue of educational institutions, admission to education institutions. Therefore, any decision given by Indira Sani case is not extended to educational institutions. It has been majority of the judges categorically stated in the Indira Sani case that till that time, right from Balaji's case up to Indira Sani case, every Supreme Court has said Article 15, the social educationally backward classes referred to in Article 15.4 and backward classes referred to Article 16.4 are one and the same. There is no difference between the two. Both identically means the same. It does not mean differently. That is what the Supreme Court said. It is a consistent view of the Supreme Court right from Balaji till Indira Sani. But in Indira Sani case, they said social educational backward class is different, backward class is different. Backward class is much wider, therefore both do not mean the same thing. Therefore, the decision given in Indira Sani case is confined only to employment under the state. It is not extended, it is not applicable to the educational institutions. But in the another important thing we know is that in Indira Sani case, though the question was only with respect to, only limited to whether the state can, whether the central government or central government of India can reserve seats in education institutions, run by it, education institutions. No, I'm sorry. In Hindustan, whether the government of India can reserve seats for in the government employment. That was the only issue. But the Supreme Court in this case went beyond its scope. That is what I would say. It went beyond its scope and said, what we say regarding exclusion of creamy layer is applicable even to states, even to state law. Even the states has to exclude creamy layer. Within 4 months, it must be done by government of India, and within 6 months, all the states must exclude creamy layer, otherwise it will not be valid. So this goes beyond the jurisdiction of the Supreme Court itself. That's what I would say. I think it is in that manner only. But still, it was an order passed under Article 142, Constitution of India. Therefore, when any order passed under 142, it is binding on all the states, it is binding on all the courts, and every institution has to respect the decision, and therefore it has to be respected. It has been respected so far. This specific inclusion or extension of the principle of exclusion of creamy layer was even to states was made in the Indrastani case. But in Ashok Kumar case, that was not done. In Ashok Kumar case, it was only restricted only to the institutions run by Government of India. That is central education institutions only. This judgment binds. Therefore, beyond that, for any state education institutions, creamy layer, by creamy layer, you cannot exclude anyone for in the case of admission of students into any institutions. Whether it is because in Tamil Nadu, we are very fortunate because of the Act 45 of 93 included 9th schedule. We are free from all those difficulties. But even every other state other than Tamil Nadu, there also they cannot exclude creamy layer insofar as the admission of students in their own institutions. If it is central education institution, the creamy layer has to be applied. But if it is not a central institution, state institution, or a private institution run by the state, within the state, creamy layer cannot be excluded, does not require to be excluded. Therefore, if they have been excluded as a creamy layer, all those things are illegal. So at least now they must realize, all the other states must realize that they need not exclude creamy layer in education for admission of medical education institution, all the other states except all other states. So this is one important aspect we forgot. We also did not notice that that is judgments must be read in full by those persons who are responsible, who has got a duty to duty. But I read it only now. Only now I am able to come identify this. So this concept of creamy layer, as enunciated by Ashok Kumar case, is limited only to central government institutions only. It is not applicable to state government institutions, whether it is in Tamil Nadu or in Andhra Pradesh, Karnataka, any other state, it is not applicable. It is one thing we have to accept, we have to bear in our mind. Then comes the present one. We have been fighting for conferment of legal status for a backward class commission, and we were all very happy when the commission was given that status. Even at that point of time, many things, as Karnanidhi has referred to you, Mr. Karnanidhi has referred to you, that so the problem that were anticipated were also cautioned by the Tamil Talaivar, the Austrian. This will be the result if you implement this, if you pass this law like this. But still, even after hearing the detailed argument, even after accepting all those arguments, the chairman of the committee said there is no requirement to change any amendment. Therefore, the act was passed without any amendment. That was the reason why when Maharashtra wanted to bring some community as backward class community, that was rejected, and the uproar has arisen because of that. All the states realized that their powers have been robbed. In my article, I have stated state loses the rights loses the right in this matter. I have written like that. That was how it was. The government of India was compelled to bring this amendment, Constitutional Amendment, 105 Amendment Act. I have written in my book in 2000, which was published in 2009, which was released by Austrier in LLA building. That was in 2009. In that, in page number 78, I have stated clearly, in order to avoid all these problems, all these case laws, all these problems relating to reservations, creamy layer, everything, it requires an amendment to the Constitution. It asks the government of India must define what is the meaning of social educationally backward classes. Once that is defined, all these problems will be over. That is what I have written in my book, page number 78, you can see that. Now, because of all these problems, the Government of India has brought an amendment to, in the 105 amendment. This amendment introduces or clarifies or defines what is the meaning of socially and educationally backward classes. This is how it is defined. Article 366, clause 26C, it defines social educational backward classes in this manner. Socially and educationally backward classes means any backward class as are deemed under Article 342A for the purpose of central government or the state or the union territory, as the case may be. This is the definition under Article 366, clause 26C regarding socially educationally backward classes. What does it mean? That means social education classes means as defined under this. Social education means any backward classes as are deemed under 342A. If you refer to 342A, you can understand 342A enables the government. 342A class 1 and 2 enables the central government to maintain a list of social education backward classes. 342A subsection 3, class 3 enables every state or union territory by law, it is not by any executive order, by law, prepare and maintain for its own purposes a list of SCBC entries which may be different from central list. So there are both state and center can make their own list of social education backward classes. This is whatever defined, whatever listed, whatever found in the entries of both central government and state government are deemed to be socially and educationally backward classes for the purpose of Article 342 capital A. That means once an entry is found in the backward classes list, that community as a whole is deemed as a backward classes. The community as a whole, without exclusion of creamy layer, it becomes entry, becomes social education backward classes. Therefore, now the Constitution has defined what is the meaning of backward classes, social education backward classes. It does not include creamy layer. It does not want. It is not necessary to exclude creamy layer in order to form part of entry, form an entry. Therefore, once an entry is found in the SCBC, either in the state list or in the union list, it is the unit as a whole, the community as the list entry as a whole has become backward classes now, social education backward classes. Therefore, there is no need for exclusion of creamy layer anymore. From 18/8/2021, you can rejoice, you can enjoy, you can celebrate that the creamy layer concept has been abolished, abrogated. Creamy layer concept has been abrogated. Article 342A class 1 and 2 enables the central government to maintain a list of social education backward classes for its own purpose. 342A3 enables every state or union territory by law to prepare and maintain for its own purpose a list of social education backward classes, entries which may be different from so and so. That means every person forming part of the entries deemed as SCBC, Social Education Backward Classes, either in the state list or in the central list, are members of Social Education Backward Classes. No person could be excluded as creamy layer. This is what it found, this is what it means. Once the amendment has been made, 105 amendment has been made, this, the creamy layer has been abolished, has been abrogated by law. The creamy layer concept brought in by the Supreme Court in Indira Sani case under Article 142 has been abrogated by law, by Constitutional Amendment 105 Amendment in the year 2021. Any decision given by under Article 142 is only a temporary measure. Article 142 though enables the Supreme Court to make any order for doing complete justice in a particular issue, still it is only a temporary law until President by order makes a law, makes an order. So President here refers only to the Parliament. When the Parliament makes a law, President signs it, only then it becomes a law. Therefore, when the presidential order is made after subsequent to the decision of the Supreme Court under 142, the President order alone binds, not the 142 judgment. Therefore, the judgment of the Supreme Court in Indira Sani case is no more a good law. You can rejoice. That is why I said you can rejoice. All those we have been fighting for removal of removal of creamy layer, we have got it now. Without fighting for it, we got it now. For it is not as if nobody can argue that the Government of India, without understanding what it contained, passed this amendment. Because even in 2008, the Vahanvadi and Justice Parasaran have stated exclusion of creamy layer is a bad law, is bad principle. So that is the Government of India's view is creamy layer should not be excluded. That has been implemented now by this 105th Amendment. Therefore, there is no creamy layer anymore in either in Tamil Nadu or in any other state in India. So that is what I feel. You can doubt whether my view is correct or not. ஒரு சீட்டு கவி சொல்லலாம்னு நினைக்கிறேன். சீட்டு கவி சொல்லலாமா? சீட்டு கவினா தெரியும் உங்களுக்கு என்னன்னு. It is self-esteem. I have given number of judgments. I have drafted number of acts. No judgment of mine has been reversed by the Supreme Court till today. No law drafted by me has been declared invalid by any court, including Supreme Court. In some of my judgments were reversed in the Madras High Court by some judges. But when it went to Supreme Court, that judgment was reversed and my judgment was restored. That is how. And one more thing, as a student also, those who studied my book would have known that. When I was a student, I wrote an article in international law. What I said in 1973 in my article in international law, the Constitution of India was amended in 1976, that is 40th Amendment or 39th and 40th Amendment, in the law of the sea. And that has become international law in the year 1982. So what I have said, I will not say anything just like that. Without thinking, deep into that, I will not say anything. And this is what my conclusion. The creamy layer is no more valid. It is not in practice now. Thank you so much for all.
தெளிவாக இந்த சட்ட நுணுக்கத்தை பற்றி இந்த 105வது சட்ட திருத்தம் இனி கிரீமி லேயர் என்கின்ற முறையை முற்றிலுமாக நீக்கிவிடுகின்றது என்கின்ற ஒரு தகவலை சொல்லியிருக்கின்றார்கள். அவர்கள் அதற்கு முன்பாக சொல்லப்பட்ட அவருடைய செய்தியிலே இதுவரை பிற்படுத்தப்பட்ட மக்களுக்கான பல்வேறு இடர்பாடுகள் வந்ததற்கான காரணம் என்னவென்று சொன்னால், அரசமைப்பு சட்டத்திலே பிற்படுத்தப்பட்டோர் பட்டியலை பற்றி எந்த விதமான ஒரு விளக்கம், டெஃபினேஷன் இல்லை. பட்டியலின மக்களுக்கு இருக்கின்றது, பழங்குடி மக்களுக்கு இருக்கின்றது. ஆனால் பேக்வர்ட் கிளாஸஸ் யார் என்பது பற்றி எங்கேயும் ஒரு டெஃபினேஷன் இல்லை. ஆகவே தான் இந்த இடர்பாடுகள் நமக்கு தொடர்ந்து வந்திருக்கின்றன. இதற்கு முன்பாக அசோக் குமார் தாக்கூர் வழக்கு 2006 கல்வி சம்பந்தமான வழக்கிலும் இது பற்றி அங்கே சொலிசிட்டர் ஜெனரல் அவர்களும் பராசுரன் அவர்களும் சுட்டிக்காட்டியதற்கு பிறகும் கூட நீதிமன்றம் அதனை ஏற்காமல் அவர்கள் கிரீமி லேயர் முறையை கல்வியிலையும் புகுத்தி விட்டார்கள். ஆகவே இந்த விளக்கம் இருந்திருந்தால் இந்த இடர்பாடுகள்லாம் வந்திருக்காது என்பது அவருடைய கருத்தாக அமைந்திருக்கின்றது. அது மட்டுமல்ல, இந்திரா சாஹானி வழக்கு 9 நீதிபதிகள் கொண்ட வழக்கு என்பது அவர்களுடைய வழக்கின் தீர்ப்பு அங்கே வேலை வாய்ப்பு மட்டும் அதிலே இருக்கின்றது, மற்ற செய்திகளுக்கு அவருடைய அந்த தீர்ப்பு பொருந்தாது என்பது ஒரு கருத்தாக இருக்கின்றது. அதே போல் அசோக்குமார் தாக்கூர் வழக்கு என்பது கல்வி சம்பந்தமாக ஒன்றிய அரசினுடைய கல்வி நிலையங்களிலே பிற்படுத்தப்பட்டோருக்கு இடஒதுக்கீடு தருவது சம்பந்தமான தீர்ப்பு என்பது ஒன்றிய அரசு நடத்துகின்ற கல்வி நிலையங்களுக்கு மட்டும்தான் பொருந்தும், மாநிலங்கள் நடத்துகின்ற கல்வி நிலையங்களுக்கு அந்த தீர்ப்பு பொருந்தாது. ஆகவே அந்த மாநிலங்களில் இருக்கக்கூடிய கல்வி நிலையங்களில் கிரீமி லேயர் என்பது எங்கேயும் அவர்கள் நிறைவேற்ற வேண்டாம் என்பது அவருடைய கருத்தாக இருக்கின்றது. இறுதியாக 105வது சட்ட திருத்தத்திலே அவர்கள் சொன்ன செய்திகள் என்னவென்று சொன்னால், அதிலே இந்த பிரிவுகள் திருத்தம் செய்யப்பட்டிருக்கின்றன. ஏற்கனவே இருந்த 102வது திருத்தத்திலிருந்து மாறுபட்டு சில விளக்கங்களை தந்திருக்கின்றார்கள். முதன்முறையாக சோஷியலி அண்ட் எஜுகேஷனலி பேக்வர்ட் கிளாஸஸ் யார் என்கின்ற ஒரு டெஃபனேஷன் இந்த சட்டத்திலே வந்திருக்கின்றது. அதாவது பிரிவு 366 உள்பிரிவு 26C பிற்படுத்தப்பட்டோர் பற்றி ஒன்றிய மாநில அரசுகள் மற்றும் ஒன்றிய பிரதேசத்தில் 342A பிரிவில் கூறப்பட்டுள்ளோர் பிற்படுத்தப்பட்டோர் என கருதப்படுவார்கள். ஆகவே 342A பிரிவு என்ன சொல்லுகின்றது என்று சொன்னால், அதனுடைய உட்பிரிவு 1 அரசு சட்டத்தின் நோக்கங்களுக்காக சமூக ரீதியாக கல்வி ரீதியாக பிற்படுத்தப்பட்ட வகுப்புகள் என்று ஏற்கனவே இருந்த அந்த சட்டத்தை திருத்தி இனி ஒன்றிய அரசின் பட்டியலில் உள்ள சமூக மற்றும் கல்வி ரீதியாக பிற்படுத்தப்பட்ட வகுப்புகள் ஒன்றிய அரசின் நோக்கங்களுக்காக என மாற்றம் செய்யப்பட்டிருக்கின்றது. அதே போல் அதில் விளக்கம் என்ன சொல்லப்பட்டிருக்கின்றது என்று சொன்னால், ஒன்றிய அரசின் பட்டியல் என்பது ஒன்றிய அரசால் தயாரிக்கப்பட்டு பயன்படுத்தப்படும் சமூக ரீதியாக கல்வி ரீதியாக பிற்படுத்தப்பட்ட வகுப்புகளின் பட்டியல். ஆக சென்ட்ரல் கவர்மெண்ட் அந்த சென்ட்ரல் லிஸ்ட் அதுதான் பிற்படுத்தப்பட்டோருடைய பட்டியல் என்று வரையறை செய்யப்பட்டிருக்கின்றது. அதே போல் அதில் உள்பிரிவு 1 மற்றும் 2 ஆகியவற்றில் எது குறிப்பிடப்பட்டு இருந்தாலும் ஒவ்வொரு மாநிலமும் அல்லது யூனியன் பிரதேசமும் சட்டப்படி அதன் சொந்த நோக்கங்களுக்காக சமூக ரீதியாக கல்வி ரீதியாக பிற்படுத்தப்பட்ட வகுப்புகளின் பட்டியலை தயாரித்து பராமரிக்கலாம். இந்த பட்டியல் ஒன்றிய அரசின் பட்டியலிருந்து வேறுபட்டும் இருக்கலாம் என்று விளக்கம் அளிக்கப்பட்டிருக்கின்றது. ஆகவே இதன்படி இனி இந்தியா முழுவதும் பிற்படுத்தப்பட்டோரை கிரீமி லேயர் என்கின்ற வகைப்படுத்தி அவர்களை அந்த இடஒதுக்கீட்டில் விலக்கி வைக்க முடியாது என்பதுதான் ஐயா அவருடைய கருத்தாக அமைந்திருக்கிறது. நன்றி, வணக்கம்.
உன் கடவுளை விட, உன் சாஸ்திரத்தை விட, உன் முன்னோரை விட, உன் வெங்காயம் விளக்கமாத்தை விட உன் அறிவு பெருசு, அதை சிந்தி.